Alrighty, everybody. Modification in contract law can be very straightforward. However, it does depend on what the applicable law is. So modification usually comes up in Contracts 1, your first semester in law school, when your professor has gone through formation, offer, acceptance, and consideration, which is a fully formed enforceable contract. What's tricky about modification is that it highly depends on what the applicable law is, whether it's the common law, or deal services, or the UCC, the sale of goods. So this is very critical to comprehend, not only for your written exams, but also for the multiple choice exams in your classroom, and especially for the bar exam. So knowing modification cold will be very, very critical. So let's go to the definition, and then we will go through what modification is under the common law and what a proper modification is under the UCC. So the common definition is when both parties mutually agree to alter the terms of the contract. An example of this is A and B have a contract, and A and B want to alter the terms of the contract after it's already been formed, right? If A and B have a contract that's under the common law, it'll look like this. So A and B have a contract that's dealing with A giving B 10 piano lessons a month. Okay, that is deal services. Consideration is needed if A and B want to alter the terms of the contract. So let's say B wants to be a better performer in terms of his skills in playing the piano, and B requests to A that, hey A, I want to have 15 lessons a month rather than 10. And B wants to alter the terms of the contract in order to get 15 rather than 10. As you can see through that example, if A agrees to alter the terms of the contract to give B 15 lessons a month rather than 10, consideration is satisfied here. Because not only is B going to get 15 lessons rather than 10, A is going to get paid more money, because every single lesson, A is getting money for each and every lesson, and by adding 5 more lessons a month, A got consideration through the 5 extra lessons. Therefore, consideration is satisfied here. And it must be fair and equitable under circumstances. In a situation like this, where A and B have that agreement to have A give B those 10 lessons, and now altering the terms of the contract, A will give B 15 lessons per month. That would be fair and equitable under these circumstances, because not only will A get more money, B will be able to be a better performer in playing the piano. Therefore, a situation like that will be satisfied under the common law. However, if there is no consideration at all, such as money or some type of legal detriment given to the other party, it will not be satisfied. A modification will not be satisfied under the common law if no consideration is there. So when you think about modification under the common law, always ensure that there's consideration implemented into what A and B are talking about. Because again, if A and B don't have a consideration, the modification will not be valid. So it's so important to mention that the modification is still there if A and B, under the common law, still tries to alter the terms of the contract. You should still raise the issue, but defeat the issue. Talk about it and say, however, due to A and B not having proper consideration, the modification is not valid. That will be able to raise modification, get your points on your exam, and also defeat the argument, therefore getting maximum point value. So it's always critical to bring up every single issue, even if the situation will get defeated. So it's important to do that. So the UCC is pretty straightforward as well. The UCC, again, is the sale of goods, And what I want you to do is to put UCC 2-209. That is technically the rule of modification. Put UCC 2-209 in your exam, dash modification. Simple as that. Because that is UCC rule of this definition. So the definition still stays the same in common law and the UCC. However, to impress your professor, to get even more point value, it is important to put UCC 2-209 because that is the proper terminology in order, again, to get more point value. So in order to have a proper modification under the UCC, it must be done in good faith. This is very, very critical. This is going to get you maximum point value in your analysis if you mention that the modification was done under good faith. So an example of the UCC in our topic here, modification. An example of a modification under the UCC is that let's just say that A and B have a contract for the sale of goods that involves A purchasing 12 TVs from B. And let's just say A and B want to mutually agree to alter the terms of the contract in order for B to purchase 20 TVs from A rather than 17. They can do that just as long as it was done in good faith and no consideration is needed. Under the common law, consideration is needed. However, under the UCC, no consideration is needed, only that the modification, the alteration of the terms of the contract, was done under good faith. So if it's under bad faith, let's just say A is trying to take advantage of B, or B wants to take advantage of A for their own personal gain, that will be done under bad faith. So that is modification for you. If you have any questions, please comment down below and I will answer it as soon as possible. I want you to be successful in law school, and understanding all these little smaller rules will help you get the edge. Thank you.